Good afternoon, everyone. Thank you so much for joining us with us for a special edition of our Lunch with the Friends series of live video presentations. I'm Chris Knopp, the Executive Director of Friends of the Boundary Waters Wilderness. I hope all of you are doing well and staying safe and staying healthy. We're all in this together and we'll get through this together. For over 40 years, Friends of the Boundary Waters Wilderness has been the leader in protecting the wilderness. And the strength of our organization is people, all of you out there. So we're a people-based organization. And today our work focuses on three areas: the wilderness, people, and communities. For the wilderness, we're involved in lawsuits, legislation, and community action to protect the boundary waters from sulfide mining. There are two mines and one threat to the boundary waters: polymetallic twin metals. Twin metals is the focus of today's discussion. For people, we have an education program, No Boundaries to the Boundary Waters program, to connect students of all backgrounds to the wilderness through classroom presentations, online presentations, and wilderness canoe trips. And then finally, we know that the communities that are gateways to the boundary waters, Ely, Grand Marais, the North Shore, and the like, have a shared future with the wilderness. That is, in order for the wilderness to be protected, those communities must thrive. Today's presentation is on the new lawsuit that we filed with our partners yesterday to stop twin metals. And before I hand this over to our attorney, Ari Lukoff, I'll put this lawsuit in context here. The Friends has been a leader in using litigation to protect the boundary waters for over 40 years. In the late 1970s, there were challenges to the Boundary Waters Canoe Area Wilderness Act, which was enacted in 1976. And so we were involved in those lawsuits to protect, to defend the act. That culminated in almost 40 years ago to the day when a very famous federal judge, Judge Miles Lord, in July of 1980, ruled in favor of the Friends and upheld the Boundary Waters Canoe Area Wilderness Act. 2 years later, the U.S. Supreme Court upheld that decision by the federal district judge. Then throughout the 1980s and 1990s, the Friends was involved in a series of lawsuits, and these included stopping military flights over the wilderness, ensuring the closure of motorized portages, stopping the expansion of motor use in the boundary waters, and challenging timber sales at the edge of the boundary waters that threaten the wilderness character. 10 years ago, in 2010, Robbins Kaplan represented the Friends in a challenge to the AT&T tower being built on the Fernberg Trail east of Ely. That is a 450-foot tower. The Friends was successful at the trial court level in challenging that AT&T tower, but we lost at the Court of Appeals level, and that tower was built. But we were in the arena, and we will always be in the arena to fight for the boundary waters. That brings us to the challenges that sulfide mining, that twin metals presents to us. And so I know the question is asked of us, what is our role in this? And the first answer to that question is, this is what we do. We've done this since the decision by Judge Miles Lord in July of 1980, when we defended the Boundary Waters Canoe Area Wilderness Act. And what we're doing today is a continuation of that. And then second, we're geographically focused. We're not a statewide organization. We're not a national organization. We love working with statewide and national organizations and other outfitters and individuals, because that makes our efforts stronger. But what we are is a geographically focused organization, and that's our strength, and that's what we bring to our lawsuits. Third, we have a multi-pronged approach to defeating sulfide mining. The lawsuits are one of those prongs, but we're also involved in challenging at the permitting level. And the presentation last week on the Twin Metals mine plan is an example of our work at that sort of regulatory permitting level. And another part of that multi-pronged effort are legislative efforts to defeat sulfide mining. And this will be a topic for a future webinar coming up here for us. And then finally, we have a holistic approach, that our efforts to defend the wilderness through lawsuits and these other means are integrated with people and communities, so that we have a holistic approach there. And so this lawsuit that we filed yesterday is just the latest step in our efforts to protect the boundary waters. Before I turn this over to Ari Lukoff, there are a couple housekeeping matters here. And so you cannot speak during this presentation, but you can communicate. And so if you move your cursor to the bottom of the screen, you can see a Q&A tab and a chat tab. And I will try to answer some of those questions along with my colleague, Scott Beauchamp, who's our policy director. And you could also make comments, and Scott and I will also work to respond to your comments that you make here. The presentation will last about 30 minutes, and we'll have a question and answer session with Ari Lukoff. So Ari Lukoff is with Robbins Kaplan. Robbins Kaplan and the team there has been a huge help to us. And Ari Lukoff has devoted an extraordinary amount of time to this. And we are incredibly grateful for his passion for the boundary waters, for his legal acumen, and for his service to all of us and to the wilderness. So, Ari Lukoff, thank you so much. Please take it from here.
Thanks for the introduction, Chris, and welcome everyone. During this webinar, I'm going to provide an introduction to the latest lawsuit that we have filed challenging the Twin Metals mine. This case was filed just yesterday in the United States District Court for the District of Columbia. That's the federal trial court sitting in Washington, D.C. And the case is named the Wilderness Society et al. Versus Bernhardt and Bureau of Land Management. David Bernhardt is the Secretary of the Interior of the United States. We filed this case with a coalition of partners, including the Wilderness Society, the Isaac Walton League, Center for Biological Diversity, Northeastern Minnesotans for Wilderness, many outfitters and resorts who own land nearby to Twin Metals leases and would be really severely impacted if the mine were to go forward. This case, like one that I'll discuss that preceded it, relates to two leases that are owned by Twin Metals. These leases are just southwest of entry points 32 and 33 on the South Cowiciowe River. I am not certain whether everyone can see my cursor, but the leases are right here in this area on the northwest edge of Birch Lake. One of the leases actually abuts the boundary waters, as shown in this image in the center of this screen. The other one is just southwest of there on both the east and west banks of Birch Lake. The image all the way on the right side of the screen actually is a screenshot from a proposed mine plan that Twin Metals has submitted to both the federal government and the state of Minnesota for approval. And what it shows is that Twin Metals is proposing that they be allowed to build a really massive sulfide ore mine on the eastern shore of Birch Lake and on the southern shore of the South Cowiciowe River. This area to the south of the image, right here, is where Twin Metals would like to store tailings from the mine. So this would be an underground mine. They would bring ore up to the surface, crush it, and then extract metals. And what's left over are all of the tailings. And the tailings are quite the pollutant. And Twin Metals is asking that they be allowed to essentially just dump and store those tailings right on the shores of Birch Lake in this huge tailings field. And there's no scale on this map, but that tailings field is enormous. It's around 1 mile by 1 mile. So it's just huge. And that's this particular litigation relates to the leases that Twin Metals needs in order to build that mine. And this is the image on the left, actually, excuse me. The image on the left actually shows the general area. This is an aerial view of where the South Cowiciowe River meets Birch Lake. It is right in this area that Twin Metals wants to build its mine. And this is really what we're fighting for here. It's this pristine wilderness right on the edge of the boundary waters. And Twin Metals really, they want to disturb the entirety of this area, with not only building a mine on that area, but enlarging roads, creating all of the massive infrastructure that would be needed in order to support a mine like this. This area is actually both directly downstream and directly upstream of the boundary waters. So water here flows from the South Cowishiwi River, and then it actually turns northward and goes back into the boundary waters. And this entire area is all within the Rainy River watershed, which is the watershed that is the vast majority of the boundary waters. It's the same watershed that then flows into Quetico Provincial Park and ultimately westward through the Rainy River and into Voyageurs National Park. All of that is all within this particular watershed, and Twin Metals wants to build a mine upstream from all of it. But this right here is what we're fighting for. These two leases by Twin Metals were granted a long time ago. They were actually originally granted in 1966 by the Johnson administration, before the enactment of all of our modern environmental statutes like NEPA, which we'll speak about, and the Clean Water Act. Those were all enacted after these leases were granted. The leases had an original term of 20 years, and they've been renewed for 2 10-year terms. So they were renewed once in 1989 and once in 2004. Twin Metals came into the field right around the time of the third 10-year renewal. Twin Metals was not the original owner of these leases. They've been transferred and assigned from company to company to company throughout that time. And even though they've now been alive for over 50 years, it wasn't until just a few years ago that any company actually wanted to build a mine there. There's been a lot of exploratory mining, but no company ever actually came forward and said, we want to use those leases to build a mine. So now we're 50 years into the lifespan of these leases, and now Twin Metals comes in to the fold with the support and being owned by a Chilean mining conglomerate, and now wants to build this mine on the leases. This particular litigation is really all about Twin Metals' request to renew the leases a third time. So it's about that 2012 application for renewal. And in 2016, the Bureau of Land Management, which is essentially the landlord for the federal government, they own the mineral rights on this land. The BLM asked the Forest Service whether it would consent to renew Twin Metals leases. And the reason for that is statutory, that under the pertinent statutes, the Forest Service, which is the federal agency that has jurisdiction over the surface of Superior National Forest and this particular land, has consent rights to renewal. And the Forest Service performed a deep analysis of this issue and issued a formal letter from the chief of the Forest Service. And that letter said that that the inherent risk of sulfide ore mining near the boundary waters was unacceptable. This was not a small document. It was somewhere around 20 pages long, very detailed, goes through all of the science. It included a multi-page bibliography citing scientific studies showing why sulfide ore mining shouldn't occur here and shouldn't occur in this watershed and shouldn't occur near the boundary waters. And as a result of that letter, the Forest Service did not consent to the renewal. And because the leases were not renewed, they were allowed to expire. And they, in fact, did expire in 2016. Shortly after the 2016 presidential election, the new administration came into power. And the Bureau of Land Management got a new legal opinion interpreting Twin Meadows leases. That legal opinion was issued by the Deputy Solicitor of, I believe it was actually the acting Deputy Solicitor of the Interior. And he reinterpreted the leases and found that Twin Meadows, in fact, had a right under the leases to a renewal. Previously, that changed the previous interpretation, in which the government said that Twin Meadows did not have a right to renew, and that the government could decide whether to renew the leases or not. So Twin Meadows and BLM now have this new interpretation of the leases that says the leases must be renewed. And so what BLM did was it reinstated the leases and restarted the process of actually renewing the leases. We challenged, the Friends of the Boundary Waters challenged the interpretation of these leases in a case which we've called the reinstatement case, and it was filed in the United States District Court for the District of Columbia. That case is now on appeal to the U.S. Court of Appeals for the District of Columbia Circuit. That appellate process is just starting, and will take some time, but we expect we hope to have a favorable decision regarding the reinstatement. And of course, if the leases couldn't be reinstated, then they can't be renewed. During that first case, the reinstatement case, BLM was also moving forward with the process of actually renewing Twin Meadows leases. And this is an administrative process. It was headed up by BLM, but it also included participation by the U.S. Forest Service. And during that reinstatement case, BLM actually renewed Twin Meadows leases for another 10-year term. This case, the latest, the case that we filed yesterday, it is a challenge to the renewal, to what the government did during the renewal, and whether its renewal was lawful under the applicable administrative acts and the National Environmental Protection Act. The main aspect of this lawsuit that the lawsuit challenges is that the leases precluded the government's ability to totally stop mining through a stipulation that they could have included in the leases. And that stipulation is called a no surface occupancy lease. And what it would do is it would reserve for the government the right to totally stop mining. And through the lack of that provision and the inclusion of several other provisions, the leases effectively encourage mining. And in fact, I think if BLM were asked, what the impact of these new leases would be, I think they would absolutely say that the goal of these new leases and the types of stipulations that were included, that those were intended to clear the way for mining for Twin Meadows. So we have several claims that we have asserted in the new litigation. The first of which is against the U.S. Forest Service, and it's a claim under the Administrative Procedures Act. Like I said before, as the Surface Management Agency with jurisdiction over this particular land, the Forest Service has the power to impose new or different stipulations, that's provisions or limitations, on the renewal leases. The first time the Forest Service performed that analysis was in 2016. And recall that they said no, they would not consent to the new leases because of the inherent risk of sulfide ore mining to the boundary water. But most recently, when the leases were renewed, the Forest Service totally changed direction. And rather than saying there shouldn't be mining here or including provisions that would preclude mining, the Forest Service either consented to stipulations or at least didn't object to them that would discourage mining or preclude it altogether. So the Forest Service changed its position, and under the law, when a federal agency changes a policy or position, it's required to explain why. And the Forest Service didn't explain why here. So that is our first claim, that the Forest Service's consent is unlawful because it's arbitrary and capricious. It's an arbitrary and capricious change in position in violation of the Administrative Procedures Act. The other claims that we have made are for violations of the National Environmental Policy Act, that's NEPA. This law is long-standing. It is now 50 years old. It was signed into law in January 1970 by President Nixon. It says itself that NEPA is the country's basic national charter for protection of the environment. And what it is that it established a national policy to promote and require agency consideration of the environment when making agency decisions. And it also established a Council on Environmental Quality. And the Council on Environmental Quality is an executive branch council that issues guidelines and regulations for how to comply with NEPA and the standards that an agency needs to meet in order to pass muster under NEPA. Broadly, NEPA requires that federal agencies assess the effects of a proposed agency action on the human environment. And it requires that an agency prepare an environmental impact statement. And an environmental impact statement is also called an EIS, and it requires that an agency do that for any major federal action that significantly impacts the human environment. So our first claim is that so all of our claims essentially rest on the fact that the Bureau did not prepare an EIS in renewing the leases, but that it was required under NEPA to have done so. And rather than prepare an environmental impact statement, what the Bureau prepared was a lesser and more abbreviated environmental assessment. These are very different because an environmental assessment doesn't evaluate the environmental impacts on the human environment, but instead it relies on a finding that there is no significant impact to the environment. So these are very different animals and very different levels of analysis. BLM did not prepare an EIS here. They only prepared the lesser environmental assessment. So our first claim is that the BLM violated the National Environmental Policy Act because it was required to prepare an EIS because it irretrievably committed itself towards a particular avenue. And that avenue was that it committed itself towards mining. And the reason that we know that it committed itself towards that is that it did not include lease stipulations that would allow the government to entirely preclude mining or other surface disturbances. So again, this is one of the ways that we know that the Bureau was actively encouraging or promoting mining through the issuance of these leases. But in doing so, it violated the National Environmental Protection Act because it did not keep for itself the ability to put a red light on the process. And what the law says is that when an agency passes the step of committing itself towards a particular avenue, that's the step where an environmental impact statement is required to be prepared. Our second claim is that under NEPA, an agency is required to consider the cumulative impacts of its proposed action, and that analysis must be quantified and detailed. What the Bureau did here was it said that the Bureau's position was that these lease renewals do not actually authorize mining because the BLM and other federal agencies would later be considering the regulatory approval of Twin Metals mine plan. And that would be the stage where an impacts analysis should occur. But it was entirely foreseeable. Everyone knows that Twin Metals is going to file a mine plan, and in fact, it did file a mine plan as soon as they got the renewal leases. Everyone knew that Twin Metals was going to pursue mining here, but the Bureau did not consider the mining as a cumulative impact of the lease renewal. And more than that, there are additional mining applications running up and down the Duluth complex, very close to the boundary waters, and the Bureau did not engage in an analysis of those as cumulatively impacting the human environment with the lease renewals. And our third claim is that the Bureau did not properly consider alternatives in its lease renewal process. The judges have described the alternatives analysis as being the heart of NEPA review. And what that means is that the alternatives analysis needs to include a true no action alternative. What the BLM considered the no action alternative to be here was that the leases would be renewed according to their existing stipulations. Essentially that they would renew it under the existing terms, and they considered the proposed action to be adding the stipulations. But what they didn't do was they did not consider a no mining alternative. They did not consider including a stipulation of no surface occupancy. And that's where BLM ran afoul of NEPA, of the requirements that NEPA imposes on the Bureau. So these are the claims that we have asserted in this case. The case was just filed yesterday in the U.S. District Court for the District of Columbia. These cases, they don't move particularly slow or fast, but we would expect the case to proceed, over the next probably year or two, headed towards a final decision, which of course we hope, and we hope that that final decision would be that that the court would declare that the renewal leases are unlawful, and effectively stop Twin Metals' right to any rights that Twin Metals might have to mine on that land. Concurrently with this, Twin Metals also submitted a mining plan, a proposed mining plan for regulatory approval at the federal and state levels. Those are under consideration, essentially under a separate track here. This particular litigation relates only to the leases and to the requirements that federal law imposes on the renewal process. There's also a separate regulatory review process that various federal and state agencies are really just starting on the mining plan. With that, Chris, should we open this up for questions? Or are there other words that you'd like to add?
Sure. Thank you, Ari. We'll open it up for questions now. And before we begin those questions, I would like to remind everyone on this webinar right now that we have 2 more days left in the special giving week here in Minnesota, and we have a $10,000 match that we hope to meet within the next 2 days here, and you can do that by going to the GiveMN website. So that would be givemn.org/BWCA. So if you go to that site there, you can support the work that we are doing stop Twin Metals and to stop Polymet, as well as our other programs here. Yeah, some of the questions, Ari, here, first, maybe you could explain, we have sort of two federal agencies here. Maybe you could kind of give broadly what the Forest Service and what BLM regulates. And so like the Forest Service is basically the surface rights, and the Bureau of Land Management, BLM, is basically the underground rights. Is that correct?
Yeah, that's right. So BLM has jurisdiction over the mineral rights here, and the Forest Service has jurisdiction over the surface rights here. It's somewhat unusual in the way that the government has organized this, but that is how the jurisdiction rests under the applicable statutes. And what that means, at least as it applies to this case, is that the leases are issued by BLM because the leases are for mining. But the mining statutes, there are two that apply here, provide the Forest Service with consent rights to that renewal. And so that's why the BLM, in renewing the leases, asked the Forest Service whether the Forest Service would consent or whether it had additional stipulations to add to the leases.
Okay. And you talked a little bit about the timing here. So I know it's kind of tough to lay out the calendar here. So after this complaint is filed, the other parties have a chance to file an answer. Maybe you want to play out what the next 6 months look like in this lawsuit.
So in general, and every case is different, but the first step is that the other parties would file an answer to our complaint. And we sued the federal government here. So the federal government would file an answer to our complaint. That answer is due 60 days after service of the complaint. After that, the court enters a scheduling order that would govern the rest of the proceeding of the case. But generally, the way that it works is that there would be the filing of an administrative record by the government. And then after that, the parties file motions essentially asking the court, we would ask the court to grant us the relief that we want, and the court would, and the government would file a motion asking the court to deny us all of the relief that we want. There is full briefing on that, an oral argument, and then ultimately a decision by the judge.
And how would Twin Metals become involved in this case?
Twin Metals could file a motion to intervene as a party. They did that in the first case, in the reinstatement case. They could do that again here.
Okay. We have some questions that talk about the potential political influence that BLM and the Forest Service are under. The sort of focus of this presentation is on the legal arguments, but it is obvious that there is extraordinary political influence involved here. And in the earlier lawsuit that Ari Lukoff referred to, our challenge to the reinstatement of the Twin Metals leases, we presented evidence to supplement the administrative record that revealed some of that political influence. It's well known that the owners of the parent company, the Chilean company Antofagasta, that the family that owns that is renting a mansion in Washington, D.C. to Ivanka Trump and Jared Kushner. So that's sort of one example of some of the influence that's out there. And going deeper into that would be a topic for another presentation. But it's clearly a challenge for us as we try to focus on the case law and the science and the facts in challenging this mine here. There are some other questions here. Let's see. That if does Twin Metals have any other options for moving forward with the proposed mine if the renewal leases are found to be unlawful? So if we win here, what happens, Ari?
So first of all, I think that's a great question for Twin Metals. I would be speculating if I'm guessing what Twin Metals would do in that situation. They do have several other prospecting permits up and down the Duluth complex. I really don't know what they would do. What I do know is that if you compare the map of their mining plan to the map of these leases are right in the middle of their mining plan. So it seemed that, and without leases, one cannot mine on that land.
There's another question here that does this lawsuit temporarily prevent Twin Metals from taking various actions?
It does not. So it does not. There's no temporary relief, at least not the kind of temporary relief like an injunction that would be granted just upon the filing of the complaint. What this does is this starts the lawsuit. This is the lawsuit that initiates our claim for relief. But Twin Metals, just the filing of this lawsuit does not stop Twin Metals from proceeding with whatever review it wants. It's whatever review it's seeking at the same time with regard to its mine plan.
A good illustration of that is the fact that Twin Metals submitted its mine plan of operation, and that last week our mine expert Steve Emmerman pointed out the deficiencies in that mine plan of operation here. Let's see, looking at some of these other questions here. There are some questions related to, has the governor taken a public stance on this? And the answer is no. As of right now, Governor Walz has not taken a stance on this. The Governor Walz and the state of Minnesota have a very, very strong interest in this and an essential role in this process. And in fact, the mine plan of operations by Twin Metals has been submitted to the Minnesota Department of Natural Resources as well as the federal government. So we are working to make sure that our voice is heard within the Walz administration, and so it's very important for all of you to make your voices heard to Governor Walz as well. And let's see some of these other questions. There are some, I guess, a question here. Well, let's see, who would be the likely purchaser of the copper produced by Twin Metals, and how are they involved in this whole process? Maybe Ari, if you want to.
Yeah, I really don't know a lot about the supply chain for the copper and the other minerals. Twin Metals would be the operating company, as I understand it, who would actually be operating the mine. But beyond that, I don't know who would be the purchaser of it.
There's, I alluded to an answer to this a little beforehand, but is there anything that an average Joe can do to make a difference? And I think there are a number of things that you can do. One on the political front is contact your elected officials, that your state representatives, your state senators, your members of Congress, Governor Walz. The second thing is you can also talk to your friends and family that live outside of Minnesota. This is a national issue, and there is federal legislation that Congresswoman Betty McCollum has sponsored that would protect the boundary waters, and you can encourage your friends and family outside of Minnesota to have their elected officials to support Betty McCollum's legislation. The third is when there are local court actions in Minnesota, or when there are local legislative hearings in Minnesota on the mining issues, whether PolyMet or Twin Metals, show up for those. That there are elected officials and our other state officials that are not elected pay attention to that, and your voice will be heard that way. And you can also support us during the Giving Week here at Give at Home Minnesota. Support Friends of the Boundary Waters Wilderness. We are a nonprofit, and we try to do the best we can with the generous gifts that people provide us. there's a, another question here about what type of exploratory work is allowed until an injunction is put in. So again, Ari, they can do exploratory work, correct?
There is a separate permit that's provided for exploratory mining. I believe that they are allowed to do more exploratory work. There was a great deal of exploration on these mines several years ago. Those who live in the area, people who live in the area, including many members of the Boundary Waters, really experience the impacts of that exploration firsthand. It's my understanding that as long as Twin Metals has these leases and that they have the appropriate permits to do more exploratory mining, that they could.
There's a question here that if BLM corrects all of its procedural lapses, then does the mine get approved, and how not? So
no. So this particular lawsuit is not about approval of the mine. This is about renewal of the leases. There's a separate regulatory process that Twin Metals would have to go to in order to get regulatory approval.
Okay. There's another question here. Could the outcome of the November election impact the outcome of this entire process?
Certainly, that's a good question, and I think it's the one thing we do know is how the Trump administration is what the Trump administration's belief is regarding the renewal of these mines, and we know what the Trump administration policy is. Certainly, there's the potential that the November election could impact it. It's hard to say in what way and to what degree.
Good deal. Well, I know we've answered a lot of questions here. I want to respect people's time. We're trying to keep this to something around a half hour, and we're a little over our time right now. Here, you can always email us with your questions, and we'll do our best to answer your questions here. As I bring this to a conclusion, I want to first thank Ari again for this outstanding presentation and for all the work you are doing with your team at Robbins Kaplan behind the scenes here. It's just an extraordinary lift, and we're hugely grateful, and everyone who loves the Boundary Waters is deeply indebted to what you're doing here. I want to particularly thank all the people out there that really the strength of our organization is you, that we're a people-based organization, and the strength of what we're doing is on the thousands of people who support us with donations and support us by advocating for the Boundary Waters out there. So I want to thank all of you for taking time out of your day to be part of this webinar here. We will make this email available to you. We'll email a link to the recording, so you'll be able to get that link to the recording, and we'll also have a link to the recording on our website here. We have these presentations every Wednesday. This is a special one, and our next presentation coming up next Wednesday, May 13th, is on fishing in the Boundary Waters. So we'll be talking fishing here. We'll be looking at tips, tricks, and secret spots for fishing in the Boundary Waters. And Rob Christ, Boundary Waters fishing enthusiast, will be doing that. I think Rob may be watching, so thank you, Rob, for doing that next week. And all of you that after the fishing opener want to get into the Boundary Waters after that's opened up, we'll update you on when the Boundary Waters is open beyond day use here. You'll be able to use these tips and tricks for having a great fishing trip experience in the Boundary Waters. So from all of us here at Friends of the Boundary Waters Wilderness, thank you so much for being part of this webinar, and have a great afternoon. Goodbye there.